My name is Arisya, and I will explain about what is the Bolam test and the relationship between Bolam test and the Bolito test.
Hi, I'm Gan Hong Yin, and I will discuss the departure of the Bolam test and the positions of the Bolam test in dealing with informed consent.
Hello, I'm Tang Pei Sing. I will be discussing the availability of Bolam tests in medical negligence cases after Montgomery and Lenashert, as well as the current position of Bolam tests in the UK.
My name is Rachel Lim Yen Wye, and I will be discussing on how Bolam test is applied in Malaysia and the broader approach of medical negligence in Australia.
Hi, my name is Joel Chu. I'm going to talk about how the approach in Roger versus Whittaker is applied in Malaysia and to what extent the approach will be adapted under the context of Malaysia.
My name is Ong June Tung. I will be discussing the current position on medical negligence in Malaysia and concluding to what extent Bolam tests can be used in UK and Malaysia.
Me, Hong Yin, and Pei Sing will be handling the first question. The question is, to what extent is the Bolam test still relevant in determining the standard of care of doctors in medical negligence cases in the UK? First, we must understand what is the Bolam test. The Bolam test states that professionals are considered as a special category on their own. The standard of care is judged in comparison to the same people exercising the same skill, which is appropriate to the professionals. In the case of Bolam versus Friern Hospital Management Committee in 1957, established the standard of care for doctors that has been used in medical negligence cases until now. It states that if a doctor acted in accordance with the other professional medical opinion, then he or she is not considered negligent. Bolam, a mentally ill patient, was treated with electroconvulsive therapy. The doctors failed to provide any means of restraint or relaxant drugs during the treatment. Subsequently, the claimant suffered injuries. Since there were doctors with the opinion that would carry out the same therapy in the same manner, it can be said that the doctor who treated Bolam acted in accordance with practices that are accepted by a number of competent medical professionals. The doctor was not guilty of negligence. This particular case has laid and served an important role for assessing the standard of care involving skilled professionals for the last half-century. The relationship between a medical practitioner and his patient is based purely on trust, which gives rise to the practitioner's responsibilities to monitor and provide care to his patient. It is understandable for the patient to believe and rely on their doctor's advice. Thus, the Bolam test was considered reliable in assessing whether or not the medical practitioner or anyone with a professional skill for that matter had breached duty of care and was negligent. The development of Bolam test continues in the case of Bolito versus City and Hackney Health Authority. A 2-year-old boy was suffering from a respiratory infection and was admitted into a hospital. The doctor that he was placed under the care of was called multiple times, but she did not show up. In the end, the boy died. The boy's mother sued the local health authority on the grounds of medical negligence. The doctor argued that she would not have intubated him regardless of her showing up or not, and this decision was upheld by the professional medical opinion. Either way, even if the doctor breached her duty of care or not, it was not the cause of the boy's death. In the first trial, 8 medical experts testified. 5 said they would have intubated the child, while 3 would not. Mr. Justice Hutchinson, the judge in the original trial, did not think that the opinion of the 3 medical experts was irrational or had no logical basis and therefore was considered in the judgment. So the issue here was to determine if the Bolam test was applicable and if this scenario satisfied the test. This case went up all the way to the House of Lords. According to the 3 of the 8 medical experts' opinion, they decided there is a logical basis and not unreasonable for a doctor not to intubate the boy. Lord Brown-Wilkinson stated that if in a rare case, it can be demonstrated that the professional opinion is not capable of withstanding logical analysis, the judge is entitled to hold an opinion of that body not responsible or reasonable. This case developed the Bolito test. It helped to shed light on what is meant by opinion of responsible body of medical men. as set out by the Bolam test, where the opinion must have a logical basis. In this case, the choice not to intubate the child was not a logical or irresponsible action, so therefore there was no breach. This case provided an alternative option for the judge. He is entitled to decide whether or not one of the opinions of the professional medical practitioner is unreasonable. Only the court is allowed to set the law, not the profession.
In Cedar Wei versus Governor, claimant was not informed that there was 1% risk that she may suffer damage to her spine before undergoing an operation. Although the operation was perfectly performed, she suffered damage to her spine and became severely disabled. She sued the defendant for failing to inform her of the risk of operation. House of Lords held that the defendants were not liable because they had followed the approved practice of neurosurgeon. Not informing the risk of damage to the spinal cord was not negligent. Bolam test was applied. However, Lord Scarman's dissenting judgment in Cedar Wei raised the issue of informed consent, and the validity of applying Bolam test on such a situation was questioned in the medical negligence cases in the United Kingdom. He argued that the Bolam test should not apply to the issue of informed consent. Doctors should have the duty to tell the patients of the inherent and material risks of the treatment proposed. He also held that in the medical aspect of advice by the doctor to their patient, the court will determine if the doctor has breached the standard of care in medical law. Cedar Wei became the first case which raised the concern on whether the Bolam test can be applied to the issue of informed consent. Later, in Chester vs. Azhar, defendant negligently failed to warn the claimant of a foreseeable risk associated with operation and caused claimant suffer the foreseeable injury during operation. Similar to the case of Cedar Wei, there was no negligence in the way the operation was performed. However, claimant argued that if she was properly advised, she would have sought another opinion on the operation. The judge found that the claimant had established a causal link between the surgeon's omissions to warn the patients of risk and the nerve damage that she had sustained, and held that the defendant was liable in damages. The Court of Appeal upheld the conclusion of the judge. The causation link was proved, and the House of Lords agreed with it. It was not clear from the judgment whether duty to warn apply only in medical negligence cases or in all cases involving professionals, but in the cases after Chester vs. Azhar, ensured that it is less likely that the duty to warn would be on in non-medical situation. When it came to the case of Montgomery vs. Lanarkshire, Bolam test was not applied anymore on the issue of informed consent. The plaintiff was a diabetic pregnant woman, and it causes her to be more likely to have babies that are larger than normal. It increased the risk of approximately 10% of shoulder dystocia during delivery. Plaintiff was told that her baby would be larger, but the defendants neither discussed nor advised of the risk of shoulder dystocia with her. Later, shoulder dystocia occurred when delivering her baby vaginally. As a result, the baby was deprived of oxygen and suffered cerebral palsy. The Court of Sessions dismissed the claim in the decision based on the approach laid down by the majority in the case of Cedar Wei vs. Governor. Decision was upheld by the Inner Court, and the claimant appealed to the Supreme Court. The Supreme Court considered whether the approach in Cedar Wei, the significance attached to patient's failure to question a doctor, was still correct, whether it was a duty of defendant to advise the claimant of the risk of shoulder dystocia if she wanted to choose to give birth by vaginal delivery, to discuss with her the alternative of delivery by caesarean section. If the claimant knew about the potential implications and the options that are open to her, the claimant would have elected to have the baby delivered via caesarean sections. Supreme Court held that Mrs. Montgomery had the right to be advised of the risk of shoulder dystocia. Not only that, she also had the right to decide for herself what risk she was prepared to run, according to the delivery. So, now, in the issue of informed consent, the Bolam test was replaced by a test where the materiality of risk involved had to be assessed by reference not to a responsible body of medical opinion, but by reference to a reasonable person in the patient's positions. Doctors are now obliged to take reasonable care to make sure that the person is aware of any material risk involved in any recommended treatment and of any reasonable alternative treatment.
I'm going to discuss whether or not the Bolam test was approved by the House of Lords in a number of cases, including Whitehouse and Jordan 1981 and Maynard and West Midlands Regional Health Authority 1985 on the issues of diagnosis and treatment by doctors. Maynard and West Midlands Regional Health Authorities is a development of establishing the breach of duty. Maynard's doctor decided to run a set of tests for Hodgkin disease, which seemed potentially lethal at that time. He did the test because he did not want to risk waiting for the earlier test result of tuberculosis. However, the test for Hodgkin disease had a risk of damage to the laryngeal nerves. In the first judgment, lower court were in favor of Maynard, but this decision was overturned with the appeals to the House of Lords. The Bolam tests were used, but this time there were two sets of skilled professionals with different views. Some were for Maynard and some against. The judge is not a skilled professional, as he could not say which group was right or wrong. Since one group agreed that would have completed the test, so Maynard lost the case as no breach could be proved. Approving the Bolam test, Lord's government said there would inevitably be differences of opinion within the medical profession. If there were another equally competent body of opinion which supported his action, it was not enough to show that the doctor had acted wrongly. Hence, it can be concluded as the Bolam test can still be applicable in deciding the issues of diagnosis and treatment. Whitehouse and Jordan is a landmark and latest decision of the House of Lords that brings to an end the sorry tales of protracted litigation surrounding this case of alleged medical negligence. Instead of clarifying the relationship between medical negligence and the concept of error of judgment, it is an underlying indictment of the present system of compensating victims of medical accidents. The fact of this case was the defendant delivered in a high-risk pregnancy which delivered a baby through forceps. It was alleged that the defendant had pulled too long and too hard in attempting a forceps, and eventually the baby had become wedges and suffered asphyxia as well as brain damage. The trial judge interpreted the terms in its medical sense and found negligence of the defendant as he had pulled too hard and too long on the forceps, causing the fetus to become wedges. When it came to the Court of Appeal, the crucial finding of facts by the trial judge was considered by Lord Denning, and it resulted in the Court of Appeal overturned the decision of the trial court. The House of Lords reaffirmed the judgment given by the Court of Appeal. This decision was regarded as important undoubtedly as the House of Lords really have the opportunity of discussing the general principle underlying the standard of care to be applied in cases of medical treatment. Lord Denning also stated, holding a dagger to every doctor's head. This implied that if every doctor were to be held liable for every mistake they made, they could not progress in their profession, as they can only progress by making mistakes and learning from them. Holding a person liable for an error in judgment, which means every single doctor would get sued as errors are made from everyday life. A good example of where an error of judgment was made is in the case of Whitehouse and Jordan. If one case of error in judgment was allowed, then it would open floodgates of litigation which is not reasonable. As we all know, the Bolam test is the earliest approach to test medical negligence. However, Lord's government dissenting judgment in Sidaway held that the Bolam test should not apply to the issues of informed consent and that the doctor should have the duty to tell the patient of the inherent and material risks of the treatment proposed. Montgomery and Lenashert appear to show that the correct test to use when informing consent should be the approach mentioned in Montgomery instead of using Bolam test. Although there are many criticisms regarding the availability of Bolam test in the UK, it is still used to this day. The best evidence for this will be Maynard and West Midlands Regional Health Authorities. In conclusion, Whitehouse and Jordan is a landmark decision that clarified the Bolam test will be used for diagnosis and treatment, while Montgomery approach will be applied to informed consent.
Moving on, me, Joel, and June Tung will be discussing on the second part of this question. Is the principle enumerated in the Bolam test still relevant in Malaysia today? The Bolam test was the test for medical negligence that had been accepted by the courts of Malaysia prior to 29 December 2006. This is the standard test used to establish whether the duty of care has been breached. It has been an applicable law in relation to medical negligence where it will be examined and judged by medical professional peers. These are the people that intend to show that they as medical professionals would have done the same if they were in the same position as them. So, the first case that I'll be mentioning is Chin Kiao and Government of the Federation of Malaya. In this case, the plaintiff was given a penicillin injection at the clinic and died an hour later. The doctor that gave the injection was found negligent as he failed to act on information. This is because the plaintiff's medical card did show that she was allergic to penicillin. The High Court held that the doctor was liable for negligence, but in the Federal Court, the decision has been reversed. On appeal by the respondents, the Federal Court had rejected Justice Ong's findings on negligence and allowed the appeal. There is a further appeal to Privy Council advising the head of Malaysia that the judgment of the Federal Court should be reversed and that of Justice Ong should be restored. Now, the question was to determine whether there was any duty on the doctor to make such an inquiry. For this purpose, Justice Ong had adopted the test of their lordships' opinion quite rightly, which was the Bolam and Frin Hospital Management Committee. Where you get a situation which involves the use of some special skills or competence, the test is the standard of the ordinary skilled man exercising and professing to have the special skill. A man need not possess the highest expert skill. And in the lordship's opinion, it is proven that the respondent, Dr. Devadesan, had failed in his duty to make appropriate inquiry before injecting the penicillin. So, now, the second case that I'll be mentioning is Khao Nan Seng and Nagama and others. So in this case, the plaintiff was injured in a road accident that involved in the motorcycle ridden by him and a motor car. The plaintiff sustained minor fractures and a plaster cast was applied to him. But the plaster cast was applied too tightly and it led the plaintiff to form an inadequate blood circulation, where gangrene formed and caused the amputation of his leg. This has shown that the plaintiff had not received a fair and reasonable standard of care and skills that was expected from an ordinary and competent medical practitioner. The breach of care consists of the lack of proper skills in application of the plaster and lack of proper observation while monitoring the plaintiff's reaction towards the treatment. As Bolam test was applied, the defendant was then held liable as all the doctors were aware of the situation that if the plaster was applied too tightly, the blood circulation would have been affected. The doctor was negligent when prescribing painkillers to the plaintiff during the complaint of pain. Now, the two cases that I've just mentioned shows that Bolam test can be applied in Malaysia, and it is when medical negligence arises in a situation, the Bolam test will be automatically applied, and this is well before the departure of the Bolam test, where the Rogers and Whittaker approach will take place. So, the last case that I'll be mentioning is an Australian case, which is Rogers and Whittaker's. In this case, Mrs. Whittaker, the respondent, was nearly blind in her right eye, and the appellant advised her on operating her right eye as it will possibly restore significant eyesight. But after the operation, there was no sign of improvement in her right eye, and she had developed an inflammation and sympathetic ophthalmia in the left eye, which was a very rare case. It has then led to a complete loss of sight in the left eye, and the appellant did not advise the respondent of the risk that this surgery holds. But there was evidence to show that the respondent had asked the doctor for possible complications about the surgery multiple times, but the doctor did not warn her of any potential risk. Dr. Rogers had then argued for this issue to be resolved with the application of the Bolam principle as described in the Lord's Command in Sidaway and Governors of Beltham Royal Hospital case. The High Court rejected the test, as if it had followed the principle, then the surgeon would not be responsible for the failure to warn. The court had overruled the perception that a doctor could not be found negligent in warning a patient if the doctor acted within the common practice, even if the practitioners follow other procedures. Now, the judges in High Court of Australia stated that the pure professional opinion merely acts as an advice and the Bolam principle has been discarded. The court has adopted the fact that it is for them to adjudicate on what is the appropriate standard of care after giving weight to the paramount consideration that a person is entitled to make his own decision about his life. And not to mention, there is also a duty to warn, as the law should recognize that a doctor has a duty to warn a patient of a material risk inherent in the proposed treatment. A risk is material if it would attach significance to the patient if he was born. So, Rogers and Whittaker's is an Australian case that only has persuasive value in Malaysia, and it is a great approach and has been cited in the cases that Joel will be mentioning next, which is Kamalam and Eastern Plantation Agency case and Fu Fiona and Dr. Su Fok Man case. So, next, Joel will be discussing on how the Rogers and Whittaker test will be applied in Malaysia.
Kamalam versus Eastern Plantation Agency, the deceased was employed by the first defendant at the time of his death and had complaint of giddiness and fainted during the work. He was then taken to the estate clinic where the first defendant, Dr. Wong, examined and discharged him after prescribing medication. A few days later, he was then attended by Dr. Yong, the second defendant. A day after visiting the second defendant, he was taken to Klang Hospital for emergency treatment due to giddiness. He was subsequently transferred to Johor Bahru Hospital and died in the hospital after. The plaintiffs brought a claim towards the first defendant for failing to provide adequate medical facilities. A claim was also brought to the second defendant on failing to diagnose the deceased of a stroke and failing to admit him into the hospital. The first defendant was negligent in failing to provide an efficient ambulance service at the material time. The second defendant failed his duty as a doctor to his patient in deciding not to admit him into the hospital. The fact that the deceased was not hospitalized contributed to the cause of his death. There was a breach of standard of care in medical aspect of diagnosis and treatment by doctor to patient. The federal court had noted that Roger versus Whittaker test was fully endorsed in Malaysia for the very first time in the case. The High Court also mentioned that the standard of care is no longer a medical judgment. Richard Talala Judge had followed the Australian case as it was an opinion for the court to consider all the factors to be involved when applying Roger test. The standard of care of a person with some special skills will not be determined solely or primarily to the reference of the practice supported by a responsible body of opinion in its relevant profession. The standard of reasonable care demanded by the law is a question for the courts to answer. In this case, the court had failed to show his duty to admit the patient into the hospital when the deceased was required. The court held that non-hospitalization for the deceased had contributed to his death. Next, I'm going to discuss why Malaysia is very reluctant to use Bolam test. In Fu Fiona versus Dr. Su Fuk Mun and Assunta Hospital is a very suitable case to illustrate this scenario. Claimant was admitted into Assunta Hospital after she had an accident. At the time of her admission, she was able to move all her limbs. First defendant ordered traction treatment. Treatment was carried out on claimant for 2 days. During that period, she was able to move her body, limbs everywhere. The first defendant discontinued the treatment after 2 days on the basis that it was unsuccessful, which then recommended surgery later. After first operation, claimant can't move her body and limbs, but the first defendant told the claimant that this condition will be temporary. Claimant would be fine in just 2 weeks' time. After 2 weeks' time, she was still in paralyzed condition. So the defendant was taken to the second operation by second defendant. After the second operation, she could only move her hands, not her legs, despite the second defendant's assurance that she would recover from her paralysis. But at the end, claimant was not able to move her legs at all. Siti Norma Yaakob, who is a federal court judge, thinks that Bolam test is not relevant to the duty and standard of care of a medical practitioner in providing professional medical advice to a patient. In Fu Fiona's case, it actually reversed the Bolam test. So it made Bolam test quite irrelevant in Malaysia. In this case, Roger versus Whittaker was applied because it provides more flexibility to the court. Court may refuse to take the response from other professional medical personnel if it is not reasonable. Roger versus Whittaker is a little bit similar to Bolito test, which my friend June Tung will explain it later. In the UK, courts apply either Bolam or Bolito depending on the situation. But in Malaysia, things can be quite interesting. Courts will consider both approaches at the same time, which is Bolam and Roger versus Whittaker. If the comments from the professional body is reasonable, then the court will still accept it. Normally, court will take the advice from medical practitioner, but at the same time, they reserve the flexibility under Roger's case. Although Roger versus Whittaker is an Australian case, but in my opinion, the function serves the same as Bolito test.
Before we look at the current position of Bolam test in Malaysia, we discuss the impact of Fu Fiona case and how it changed the position of Bolam test. In Dominic Puthucheary and others versus Dr. Gun Siu Feng and another, the decision was influenced by Fu Fiona principle. Justice Court of Appeal Gopal Siram delivers the judgment by holding the plaintiff quite rightly relied on Fu Fiona principle, hence reserving his comments towards the correctness of Fu Fiona principle, dismissed the claim as it is plainly binding on court. From his statement, we know that Gopal Siram might not keen on following the decision in Fu Fiona, but he had to due to hierarchy of courts, and this led to Roger versus Whittaker test was applied in claim of misdiagnosis or wrongful treatment. Also, in case of Hassan Datuk La versus Kerajaan Malaysia, Court of Appeal reaffirmed that Roger versus Whittaker test not only applied in provision of advice of risk, but in relation to treatment as well. And Bolam test was wholly rejected. After that, we will go to Zu Haslimah Binti Hassan Basri and others versus Dr. Kupu Velumani P and others. In this case, it solved the issue regarding which test should be used in medical negligence, and it presents the current position of Malaysia in dealing medical negligence. In this case, the first appellant pregnant and went to hospital complaining abdominal pain. He was attended by a nurse and some medication were given after various checks. After that, first appellant collapsed as a result of severe bleeding, and second appellant was delivered alive but suffered a cerebral injury due that she has ruptured blood vessel at placenta. It was held in High Court the claim is dismissed as the respondent could not have foreseen the appellant suffered from an abnormal presentation of uterus without surgery. Hence, the caesarean section did not perform before her collapse, where in Court of Appeal, the judge affirmed the High Court decision. Question of point of law raised, and this case was brought to Federal Court. The question is whether which test should be applied when considering medical negligence. As the judgment given, the court held that suitable test to use will be Bolam test if the issue raised were regarding diagnosis and treatment, where the medical practitioner will have a better say as to where is the negligence. As there is different view among the practitioner, by applying Bolam test, the respondent was not negligent. The court further explained the test of advice on risk should be treated separated. As in Fu Fiona, although they referred to the Australian approach from Roger versus Whittaker, it was not relied upon the ratio decidendi. Hence, this case must necessarily limited to duty to advice of risk. From what my friend Pei Sing have concluded just now, in UK, there is ambiguity when new approach in Montgomery depart from Bolam test. This issue resolved by the case of Whitehouse versus Jordan, where the Bolam test is considered as the correct approach to use in diagnosis and treatment. This is confirmed in Obiter Dicta stated by Lord Denning in the case. In Malaysia, the court did adapt principle from Bolam test and develop it to a wider approach stated in an Australian case, which is Roger versus Whittaker. In Fu Fiona case, the wider approach is applied and leave the position of Bolam test unknown. After that, it leads to some other case, such as Dominic Puthucheary, that follows the decision made in Fu Fiona. Besides, Malaysia did recognize the Bolito test as well, where in case of Lecture Manas Sebagar, anak lelaki S. Karupaya, versus Dr. Thomas Yao Pak Cheng and another, and the case of Chen Tam Kong versus Excellent Strategy Sendiam Berhad and others, the court used Bolito approach, although the decision in Fu Fiona reversed Bolam test. The explanation of this will be following the judgment of Fu Fiona. It mentioned the key of the test is actually if he or she acted reasonably and logically and get his fact right. Hence, by following this judgment, it will reverse the Bolam test, but Bolito test will remain applicable in Malaysia, where it does not contradict to the judgment. This issue was resolved in Zu Haslimah by giving a clear guideline stated where it is restrict that Fu Fiona approach that developed from the Roger case to the duty to advise of risk. While Bolam test will continue to be a correct test when it comes to diagnosis and treatment, as the medical practitioner will be more appropriate to determine whether or not the procedural or the method used by the doctor is correct. As conclusion for everything, Bolam test is still relevant in Malaysia. However, this approach will be restricted in settling the issue in diagnosis and treatment, where this test can also be replaced by Bolito test if the judge feels that it is unreasonable to follow the decision made by the medical practitioner.